Okay, our third and final case this morning is Kevin Kelly versus Lime Tree Village Community Club Association. Okay, Counsel.
Morning, Your Honor. May it please the Court, my name is Fred O'Neill. I'm here representing Kevin Kelly, the plaintiff below, the appellant in this appeal. This is an appeal from an order dismissing a complaint with prejudice. Briefly, the facts of the case are that in 1978, a declaration of covenants and restrictions was recorded for the subdivision where my client's property is located. The declaration, two important points about it. The first is that there was no mention of creating a homeowners association. The second is that there was amendment provision that allowed the declaration to be amended by a document executed by the owners of 2/3 of the lots affected by the declaration. In 1984, the appellee was incorporated by the developer and was deeded property for recreational purposes. The Recreation Association was set up on a voluntary basis to allow those people who purchased in these two subdivisions to join if they wished. It was not mandatory. In 2002, there was a purported amendment recorded to the declaration, the 1978 declaration, that was purportedly executed by the owners of 2/3 of the lots of the subdivisions affected by the declaration. In the complaint, with great detail, go through the 223 joinders and point out that 6 of them are duplicates, actually 12, but 6 of those are not good because they're repetitive. They'd already had joinders executed by the owners. And another 6 were executed by former owners, not owners at the time the amendment was recorded.
Was your client aware of these 2002 amendments? Were they already in place when he purchased the property?
I think he purchased shortly after it was recorded, correct. In 2009, by operation of the Marketable Record Title Act, the 78 declaration expired, and because it expired and the validity of the 2002 amendment was dependent upon the 78 declaration, it expired as well. In 2016, the appellee filed a petition with the Department of Economic Opportunity to revitalize the 78 declaration as well as the 2002 amendment. The way the proceedings are set up under Chapter 720, Part 3, is it's actually recorded, and then if somebody has an objection to it after the fact, they can file a petition to attack the revitalization by the department. That was done here by my client, and during the course of the Division of Administrative Hearings proceedings, it was agreed between the parties, the Department of Economic Opportunity, the appellant, and the appellee, that Department of Economic Opportunity did not have jurisdiction to make a determination of a couple key issues on the question of whether the revitalization was proper or not. So a joint motion was executed by myself on behalf of my client, opposing counsel's law firm on behalf of the appellee, and the Department of Economic Opportunity, that the case would be abated, that the abatement would continue until the Circuit Court of Orange County decided 2 key issues to the question of the validity of the revitalization. In 2018, February 2018, filed the instant action, the complaint. Count 1 was for declaratory relief as to the 2 issues the parties had agreed that the Circuit Court of Orange County should decide. There was a second count for quiet title of the revitalized covenants and restrictions that were recorded in March of 2016, and then there was a third count for slander of title for the recording of the March 2016 revitalized covenants and restrictions.
By the parties, excuse me, agreeing that the circuit court would decide these issues, you're not saying that then the appellee has waived any statute of limitations argument, are you?
One more time, Your Honor.
Is it your position that the appellee has waived the statute of limitations argument?
Yes, Your Honor. That's one of the positions, and we've cited the case law, and the court's probably aware that statute of limitations is an affirmative defense, like pretty much any affirmative defense, it can be waived, and it can either be waived by an express waiver or a waiver implied by conduct. And in this particular situation, where they executed the joint motion that said the Circuit Court of Orange County shall decide these two issues, that impliedly, we believe, by that conduct, they consented to the Circuit Court of Orange County doing what we agreed they would do, which was decide those two issues, which is count one of the complaint below. And frankly, and I think I put it in my brief, I don't see how you can read the joint motion and come away with any other conclusion than they agreed that the Circuit Court would decide the two issues, which are the issues in count one of the complaint. The other reasons why we think the court erred in dismissing count one is, as the court is aware, the elements for declaratory relief, one of them is that there has to be an actual present need for declaratory relief. And in this particular situation, if you take a look at the standards for evaluating whether a trial court properly dismissed a complaint based on statute of limitations, on a motion to dismiss, two things have to jump out at you. First, it has to conclusively appear that the statute of limitations bars the action. And then secondly, it has to conclusively appear that the plaintiff could not plead an avoidance to negate the statute of limitations as a defense. And again, we're coming back to the joint motion where they agreed that the Circuit Court of Orange County would decide these two very issues. If it had been pled as an affirmative defense rather than a motion to dismiss, we would have come back by reply and said, but you agreed that the Circuit Court should make this decision, and by doing so, you agreed that there should be no impediments to the Circuit Court doing exactly what you agreed that they should do. Secondly, until the joint motion was executed in August of 2016, there was no present practical need for a declaration. And there's nothing on the face of the complaint that shows that there was a present practical need for declaration prior to the agreement of the parties and the Department of Economic Opportunity that the Circuit Court should enter a declaratory relief. Third, the rationale for a statute of limitations is, and it's pretty obvious, that with the passage of time, documents are lost, memories fade, witnesses move, some die. In this particular case, everything is provable from the record, the public record. There's no rationale for the application of the statute of limitations as far as loss of memory or loss of documents or something like that. Doesn't apply here. An argument raised in our reply in the Florida Supreme Court's decision in Alley versus Ionata, the Supreme Court said, statute of limitations bars complaints, it bars a plaintiff from bringing an action. This is a kind of a bass-backwards situation where the actual initiation of this whole dispute was when the appellee applied to the Department of Economic Opportunity to revitalize the 78 Declaration and the 2002 Amendment. They initiated that, and because of the bass-backward way that the statute says that they get to record, then we can file a petition, we became the plaintiff, even though we were the ones who were defending the status quo ante before these 78 Declaration and 2002 Amendment were re-recorded.
But isn't there an argument to be made that the proper time to challenge the 2002 amendment would have been prior to 2007? Because he owned the property, he had knowledge of the amendment, that was a 5-year time frame. It was well before it expired.
Correct.
So there was kind of an issue pending then. Why was it not challenged then?
You know, I'd have to go outside the complaint But if I were to go outside the complaint...
Don't go outside the complaint, but how would you argue that the statute of limitations did not run as to challenges to the 2002 amendment in 2007?
Well, if you... with the three cases that were cited in the answer brief, where the 5-year statute of limitations was applied to declaratory relief on an amendment, those dealt with just the recording of the amendment. What we deal with here is not just the recording of the amendment, it's the re-recording of the amendment in 2016. And I think I cited to the court a number of cases that this court has decided on the multiple publication rule, where you publish a falsehood and then you publish a falsehood again, that if the second time the republication of the falsehood starts the clock running again on the statute of limitations. That's the fact scenario here, not the fact scenario of just an attempt to invalidate the 2002 amendment.
Is the earliest that Mr. Kelly could have brought the cause of action, was that in 2002?
If there had been an actual present need for declaration, again, I'd have to go outside the complaint and say, no, there wasn't an actual present need for a declaration back in 2002. And I don't know how far you want me to go outside the complaint, but if there was never an attempt to enforce it against Mr. Kelly, would there have been an actual present need to have a declaration at that point in time? The second count, the quiet title count, is to quiet the title as to the revitalized covenants and restrictions. There's no pleading to quiet the title as to the 2002 amendment. The covenants and restrictions, the revitalized covenants and restrictions, were recorded in March of 2016. The Enloe case that was decided by this court a couple weeks ago quoted and cited 95031 sub 1. That says a cause of action accrues when the last element of the cause of action occurs. If we're filing the quiet title as to something that was recorded in March of 2016, again, common sense, that's the date that you would run a statute of limitations on quiet title from, when the document was recorded that you're trying to quiet the title against. Similarly, count 3 on slander of title, it's as to what was recorded in 2016 that we're alleging slanders the title of my client. That last element of a cause of action for slander of title occurred in March of 2016, well within the 2-year statute of limitations. And then the final issue on appeal that we've raised was the add-on paragraph of the order dismissing the complaint with prejudice as to the essential elements that need to be pled in a cause of action of slander of title. And as we pointed out in our briefs, the cases that were cited to the court by appellee say what appellee says they say, that a plaintiff needs to plead and prove actual inducement not to deal. However, there are also cases, and pointed out in the Florida jurisprudence article, that say they list the elements for slander of title, and that's not listed. And in the brief, I tried to go back and find, and I'm sure better scholars can do a better job than I do, the genesis of where this split on what the essential elements of a cause of action for slander of title are. And as best I can tell, it's the restatement which says that that's not an element that needs to be pled and proved, and Prosser, which says that it is an element that needs to be pled and proved. And I think I pointed out in my brief that even Prosser recognizes that as commercial transactions, real estate transactions progress and become what they have become today, that it's impossible at this point to tell who was induced not to deal with a particular piece of property based on what's in the public record. And with the internet, you just don't know what you just don't know. There could be people out there that wanted to buy my client's property but checked the record and saw, ooh, this is buying a lawsuit. I don't know if I want to get into this. We just don't know. And for that practical reason, I think the better reasoned statement of what today, with commercial transactions today, is the statement in the restatement that proving an actual inducement of a particular person not to deal should not be an element in a cause of action for slander of title. If you have no other questions, I'll reserve the rest of my time. Thank you, Your Honors.
Thank you.
Good morning. May it please the court. My name's Toby Snively. I represent the Applee Lime Tree Village Community Club Association. This case is about whether covenant revitalization creates a new statute of limitations for otherwise time-barred claims. I'd like to start with the three cases cited by the trial court in its order of dismissal when it determined that Section 95.112B applies and prevents the appellant's causes of action. After that, I intend to explain why the waiver argument is without merit, and then if there's time, I'll rebut the remaining arguments raised by the appellant, including the multiple publication rule, and hopefully there may be time for me to conclude with the necessary elements of slander of title. The cases of Harris, Silver Shells, and Hilton establish that the statutory period for challenging an amendment to a community association's declaration begins to run as soon as that action may be brought by a given plaintiff, and the statutory period expires 5 years later. The cases state that if a plaintiff allows 5 years to pass without filing an action, that action is time-barred for that plaintiff. Now, applied to the present case, the 2002 amendment was recorded in January of 2002, and the appellant could have challenged it in July of 2002 when he acquired title. But he didn't, so the 5 years passed and the statute of limitations expired for the appellant. Now, interestingly, the record on appeal today includes an additional factual wrinkle that wasn't present in the three cases cited by the trial court, and that's the fact that the amendment at issue eventually underwent the covenant revitalization process. But what I need to impart to this court is that this is not a unique fact pattern. Nearly all amendments are eventually preserved or revitalized. Otherwise, they lapse by operation of MARTA, and that's not the most common fact pattern is the fact pattern you have today. There's a revitalization. And like the trial court, I respectfully submit that there's not a right to get a second bite at the apple. And in fact, the legislature predicted that there would be time-barred challenges when documents are revitalized. And it addressed this in Section 712.07. It states, "Nothing in this law shall be construed to extend any statute of limitations." The legislature foresaw the fact pattern that we have today and proactively addressed it in MARTA. Covenant revival shall not be construed to extend the period for 1, the bringing of an action, or 2, for the doing of any other act required under any statute of limitations. To disregard Section 712.07 and hold otherwise would mean that the statute of limitations period is really only from 5 years up until there's a preservation or revitalization, and then there's a whole new statutory period to bring a new cause of action, and that would defeat the purpose of the statute of limitations. So consistent with the directive of 712.07, the trial court found that the statute of limitations and the decisions of Harris, Silver Shells, and Hilton remain applicable even when there's a covenant revitalization. The trial court also properly recognized that based on the allegations of the complaint, the 2016 revitalized declaration is invalid only if the trial court were to first declare the 2002 amendment invalid. And the case law is clear. The appellant statute of limitations for challenging that 2002 amendment, it expired back in 2007. So consistent with the principle that litigants are not permitted to accomplish indirectly what they're prohibited from accomplishing directly, I respectfully submit that the trial court got it right. Based on the face of the complaint, it's inescapably clear that all challenges to the 2002 amendment, directly or indirectly, expired back in 2007 for this appellant. And I believe that covers the cases cited by the trial court. Now I'll rebut the argument there was an intentional relinquishment, a waiver of the statute of limitations. So the appellant argues it should be given an opportunity to raise waiver to avoid the statute of limitations. As alleged in the complaint, the appellee revitalized this declaration in 2016. The appellant challenged the revitalization administratively, not based on any procedural error with the revitalization itself, but based solely on the enforceability of the 2002 amendment. The revitalization was approved by the membership. The appellant didn't challenge that. And now on appeal, the appellant argues that there was a relinquishment of, that when jurisdiction was relinquished from DOA to the circuit court, that this somehow constituted a waiver of the statute of limitations. However, based on the face of the complaint and the exhibits, the trial court properly disposed of the waiver argument. In fact, the appellee joined in the joint motion to relinquish jurisdiction for the very reasons raised in its motion to dismiss. The claims are time-barred for this appellant. Now, prior to creation of this waiver argument, both parties acknowledged that the statute of limitation was a necessary sub-issue to be decided. Both parties recognized this. The appellant even filed a memorandum of law regarding this. The memorandum of law was originally filed as part of the DOA proceeding, and it was again filed as an exhibit to the complaint for the trial court to consider as part of the motion to dismiss. Specifically, the appellant frames the issues and sub-issues in its memorandum of law, which again was attached to the complaint at page 11. The primary issue is whether the 2002 amendment was effective. At page 12, put another way, is it too late now for petitioner to question the validity of the 2002 amendment? At page 24, put another way, is there any action or argument contesting the validity? Let me read it correctly. At page 24, the memo states, put another way, is any action or argument contesting the validity of the 2002 amendment now time-barred? So in the memorandum of law, the appellant itself acknowledges that the statute of limitations is the necessary sub-issue. And then at pages 24 through 29, these 5 pages cite the case law on the statute of limitations issue. The trial judge disposed of the waiver argument based on the face of the complaint and the exhibits. And in fact, in the transcript, he says, I don't think that's what's happening here. Waiver is an intentional relinquishment of a known right, and that's not what happened in this case. And I believe the 3rd District opinion in Bott, that's 949 Southern 2nd 295, cited in the appellee's answer brief, is a well-reasoned opinion that provides a good roadmap for this court to affirm the trial court's order of dismissal. In Bott, the Botts appealed an order dismissing their challenge to a restrictive covenant, similar to the present case. The basis for the dismissal was the 5-year statute of limitations contained in 95.112b, the same statute of limitations at issue in the present case. In avoidance of the statute of limitations, the Botts raised a condition precedent. The 3rd District found that the facts pled in the Botts complaint established that the claims were time-barred, and thus dismissal was proper. The court found insufficient merit in the Botts' argument that a condition precedent had to occur. This was apparent from the face of the complaint, and the determination was made at the motion to dismiss stage. The same is present in the case before this court. The complaint and its exhibits conclusively established that the statute of limitations expired in 2007. And there's no merit to the waiver argument. I'll now shift gears and relatively quickly rebut the 5 remaining arguments raised by the appellant to circumvent the statute of limitations. With regard to count 1, declaratory relief, the appellant argues there wasn't a present need for the declaration until 2016 when jurisdiction was transferred to the circuit court. That the 2002 amendment was a dead letter when it expired by operation of MARTA back in 2009. However, the cause of action for declaratory relief existed in 2002 when the appellant took title to his property subject to the 2002 amendment. The statutory period begins to run as soon as an action may be brought. That's clear from the cases cited by the trial court. Therefore, the appellant's 5-year statute of limitations expired back in 2007, long before the complaint alleges there was a dead letter, and very long before the complaint was filed in 2018. With regard to counts 2, quiet title, and counts 3, slander of title, the appellant argues the causes of action didn't accrue until the last element occurred in 2016 when the revitalized declaration was recorded. Now, on the surface, on the face, that seems to have some traction. It sounds like a logical argument. However, counts 2 and 3 challenge the validity of the 2002 amendment. The 2016 revitalized declaration is invalid only if the court were to first declare the 2002 amendment invalid. And we know the statute of limitations for challenging the 2002 amendment expired in 2007. So I respectfully submit that the outcome provided by the trial court is required, and it's consistent with the express language of MARTA, and it's consistent with the purpose of the statute of limitations. Now, in its briefs, the appellant cites to Section 95.031 Florida statutes titled Computation of Time. The statute states, except as provided elsewhere in these statutes, the statute of limitations runs from the time the last element constituting the cause of action occurs. But the first part, the first line, is very important. Except as provided elsewhere in these statutes. In this case, we're dealing with MARTA, Chapter 712, the Marketable Records Title Act. And at Section 712.07, titled Limitations of Actions, it states that covenant revival shall not be construed to extend the period for the bringing of an action or for the doing of any other act required under any statute of limitations. So this means for the purposes of computing time, the appellant's limitations period for challenging the 2002 amendment directly or indirectly expired in 2007, and that's not altered by the revitalization. Moving on to an additional argument raised by the appellant in its briefs, it argues the passage of time doesn't validate an otherwise invalid instrument. Essentially, that if the 2002 amendment was invalid, ineffective at the time it was recorded, the fact that 17 years has passed doesn't make it valid. However, the series of cases cited by the trial court analyze and apply Section 95.112b, Florida statutes, to causes of action that challenge the validity and enactment of an amendment to a community association declaration, the exact same fact pattern we have here. And this precedent establishes that any such challenges must be brought within 5 years. And so, I'm not arguing that the passage of time validates an otherwise invalid instrument. Expiration of the statute of limitations doesn't resolve the underlying merits. It merely cuts off the remedy for a party that failed to take action. Moving on to an additional argument raised by the appellant in an attempt to avoid the statute of limitations. The appellant relies on the multiple publication rule for the proposition that each circulation of the same defamatory document is a separate cause of action. However, the multiple publication rule doesn't apply in this context. Otherwise, a new statute of limitations is created each time a community association distributes a copy of its declaration, each time there's a title search, each time a recorded declaration is preserved or renewed, each time a recorded amendment incorporates a declaration. This would be contrary to Section 712.07 and contrary to the purpose of the statute of limitations. It's an unworkable proposition in this case. The associations record, and upon request, they provide homeowners copies of the governing documents. It's unworkable to suggest that an association should be required to record a redacted version of the declaration each time there's a challenge, or redact portions of the declaration before it distributes to homeowners who request it. As this court noted in Ashraf, when it declined to apply the multiple publication rule, unlike in the credit reporting context where a plaintiff may not know of the contents of their report until after the limitations period has run, the plaintiff in Ashraf had notice when the statement was published. Similarly, in the present case, we're dealing with a document publicly recorded back in 2002, pursuant to Florida's notice-type recording statute. The concern that prompted courts to create the multiple publication rule, that concern being that it was unlikely that the party defamed, that the party wouldn't have reason to know they were defamed until after the limitations period expired, that concern is inapplicable in the context of a document publicly recorded. This case is also very different in another reason for which the multiple publication rule is entirely inapplicable, is that this case deals with two separate recorded legal instruments, a 2002 amendment, a 2016 revitalized declaration. In all the case law that I've seen and that's been cited in the briefs, never has the multiple publication rule ever been extended beyond the recirculation of the exact same defamatory document. So for those reasons, the multiple publication rule is inapplicable. Moving on to the continuing tort doctrine. The appellant mentioned the continuing tort doctrine as another vehicle by which to avoid the statute of limitations.
Counsel, was that or the multiple publication rule brought up below to the trial judge?
I don't believe so. No, I saw them on appeal in the initial brief.
So they were never raised below.
Not to my knowledge. Continuing tort doctrine, I'll be brief. It's just not a good fit. I struggle with the continuous aspect of that argument. As articulated by the 3rd District in Chakra 5, a continuing tort is perhaps best understood as a tort in which the wrong cannot be described as a discrete event. Applied to this case, we have 2 discrete events: the recording of a 2002 amendment, the recording of a 2016 revitalized declaration. The continuing tort doctrine is not a basis for extending or creating a new statute of limitations, contrary to the express language of MARTA 712.07. Moving on, finally, appellant argues it's not necessary to plead actual inducement of others not to deal with plaintiff in order to state a cause of action for slander of title. And I respectfully submit that this issue is not outcome determinative here on appeal because the trial court properly dismissed count 3 slander of title based on expiration of the statute of limitations. But since this was part of the trial court's ruling and part of the appeal, I'll briefly address it. The cases most commonly cited for the elements of slander of title include an element of actual inducement. And from a practical perspective, this makes sense. A plaintiff should be able to explain how he's been harmed by a recording. Otherwise, perhaps another cause of action is more fitting, maybe quiet title, maybe something else. I think the trial court's approach is logical, and it's supported by the majority of the circuits as well as the federal courts. Speculation is not sufficient to create a cause of action for slander of title. In conclusion, I'd like to leave this court with 3 thoughts, if I may, please. The first being, the 3 cases cited by the trial court established that the statute of limitations has expired. 2, Section 712.07, Florida statutes, makes clear that covenant revitalization shall not be construed to extend any statute of limitations. And 3, the facts pled in the complaint and its exhibits conclusively establish the claims are time-barred as a matter of law. And for these reasons, I ask that you affirm the trial court's order of dismissal. I have a few moments if there's any questions.
Thank you.
Thank you.
Counsel, could I have you
Yes.
address the argument that 71207 pretty explicitly says that the revitalization statute does not extend current statute of limitations?
No, I totally agree, but you have to understand the posture this case is in. This isn't a situation where we brought in 2018 a declaratory relief action, a quiet title action, a slander of title action, separate and apart from the revitalization that was going on in 712. Why did we even bring this? Why did we even bring this lawsuit? It's because we challenged the revitalization in Chapter 712, and in Chapter 712, the Department of Economic Opportunity said, we don't have jurisdiction to settle these 2 questions. You need to go to the circuit court. Would we have done that otherwise? Why would we have done that otherwise? We were trying to resolve everything in front of the Department of Economic Opportunity. Department, appellant, appellee agree. You're right. The only court that has jurisdictions to resolve these questions, which will get resolved and then it'll go back to the Department of Economic Opportunity, is to send it to the Circuit Court of Orange County. It's not that we wanted to go to the Circuit Court of Orange County. We agree. 16 years after the fact, we agree. It's but for Chapter 712. I wouldn't be standing here. Counsel wouldn't be standing here. It's 712, which includes 71207. It's within, this is all an adjunct to the revitalization that was going on in front of the Department of Economic Opportunity. And again, I don't know how to stress this. It was agreed. Everybody agreed in those proceedings. Get the circuit court to answer these 2 questions, then come back. That doesn't settle the question. Get them to answer those questions, then come back to the department, and we'll resolve what we have to resolve.
Counsel has argued that the statute of limitations was one of those issues.
He is
Are
totally
part of
and
the issue.
completely wrong. There's certainly nothing on the face of the complaint that said that they raised that in front of the department. And if you want to take judicial notice of the proceedings, you can go online. Department of Administrative Hearings has the case file. Look and see for yourself. Was it raised by the appellee in front of DEO? Answer, no. But go see for yourself. Take judicial notice of those proceedings. See if it was raised in anything that they filed. And the answer is no. And that's why if they had, this would all be very, very different. But it wasn't, and so all the parties agreed, and we went to the circuit court, but that's not going to be the end of the matter. The circuit court's going to make, 2 answers, then we go back. And that's all we're asking. We're just asking that we do what everybody agreed we do in the proceedings under Chapter 712. I'm sorry, Your Honor. I got a little heated there.
Let me ask you a question
Yes.
as well. Mr. Snively spent a lot of time discussing Harris and Silver Shells and Hilton, the 3
Yeah.
cases that the trial court relied upon in dismissing
Yes.
this. And
Yeah.
none of those cases are even mentioned in your initial brief.
No,
In your
because
reply-
ours is...
Hang on a second, I'm
Yes,
asking you a
I'm
question.
sorry,
Your
Your Honor.
reply
Again, I'm
brief
getting too
starts to
excited.
address them. You spent about, I don't know, a paragraph or so trying to distinguish them, and I didn't really follow your logic in trying to distinguish those cases. Could you try to do that for me now?
Yes. Those cases dealt with direct attacks on amendments to declarations. 5 years, you're out. Direct attacks on that. Our fact situation, and the question of applicability of the statute of limitations, a fact question. Our fact situation is we're sitting in an administrative hearing up in Tallahassee for the DEO to do what the DEO has to do. They need an answer to 2 questions. They say we don't have jurisdiction to answer those 2 questions. Only the Circuit Court of Orange County has jurisdiction to answer those 2 questions. I agree. Appellee agrees. We execute a joint motion. We abate the administrative proceedings, and we do what everybody agreed we're going to do. We go back to the Circuit Court, or no, we don't go back. We go to the Circuit Court of Orange County. We say answer 2 questions. Again, that's not going to be the end of it. They'll answer the 2 questions. Then we got to go back to Tallahassee. And Tallahassee has to make this determination. So it's very, very different factually from just a direct attack, 16 years after the fact, a direct attack, a direct attack, a direct attack. Very different factually, Your Honor, as I see it. But what you see is the important thing. And as far as the multiple publication rule, your question to counsel, again, the case law says, on the face of the complaint, does it conclusively negate that we could not avoid the raising of the affirmative defense of statute of limitations?
You're out of time, counsel.
Yes, I'm sorry, Your Honor. Thank you. Thank you, Your Honors.
Thank you very much, and court is in recess.